which would be taken by Mr. Emmanuel Olomu. Mr. Emmanuel Olomu is the registrar of the Forensic Investigator Society in Nigeria. And Mr. Olomu is the author of the books Question Document Examination for Investigators, Practical Guide to Private Investigation, Forensic Crime Scene Investigation, Determining the Age of Documents, Forensic Investigation of Video, Audio, and Images File. And all these books are available on Amazon. And this morning, Mr. Emmanuel Olomu would be speaking to us on cross-contamination and legal proceedings. Over to you, Mr. Emmanuel.
Good morning, everyone.
Good morning, sir.
Okay, can you hear me clearly? Okay.
I can hear you.
Clearly, sir.
Yes, once again, my name is Olomu Emmanuel, or Emmanuel Olomu. I'm the registrar of the association. I'm a private investigator and a question document examiner. And I have a lot of published book on this feed. You may get them on Amazon, as we were told, on Amazon, eBay, and some other platform on the internet. Just type Emmanuel Olomu books. You see them, maybe even on Google Books. I stand on the existing protocol. The topic before me is cross-contamination and legal proceedings. Cross-contamination and legal proceedings. I'm trying to share my screen, but because of network problem here, can you see it? Can you see my screen?
Yes, we can see your screen.
And you can hear me clearly?
And we can hear you clearly.
Okay. Cross-contamination is from the word contamination. And contamination refers to unintentional transfer of trace evidence to an object of relevance at any point in the forensic investigation process. Wherever two objects come in contact, there's always transfer of material. And this material is what we refer to as trace evidence. In the same vein, wherever any criminal or suspect comes in contact with a crime scene, the crime scene is either the location where the crime took place or the body of the victim. So when there's contact between the crime scene and the suspect, then there is going to be transfer of trace evidence. That is, the suspect will deposit some of his trace evidence, some of his character, some things that you can use to link him, that you can use to identify him. He will deposit it on the crime scene. And when the investigator is coming, this investigator is coming to look for the trace evidence, which can be used to link the suspect to the crime scene or to the victim. Now, in the process of doing this, the investigator may mistakenly, unintentionally, it must be done unintentionally. If it is done intentionally, that means that is fraud. But it must be unintentionally, mistakenly, transfer some of the trace evidence from any part of the crime scene to an object of relevance. An object of relevance in that case is any object that may help to unravel the investigation, to solve the crime, to find solution to the crime, to solve the crime. Now, if such a thing happens, maybe probably the investigator is coming into the crime scene, probably in a house, and touches a place like handle of the door. He might have touched a DNA of someone deposited there, and if he didn't follow proper procedure, his hand or the glove that he used may take part of this trace evidence and deposit it on any of the object of relevance in the crime scene. So by the time you take the object of relevance to the crime to the lab, then the same thing that you found there might have been transferred to it by the investigator himself, because of the fact that he has touched it, he has touched that thing or took it from another place. But it will now seem as if the trace evidence is from the object of relevance. For example, somebody in the case where you have the case of burglary, an investigator is coming and now enter to process trace evidence in that place. The man might have mistakenly take some trace evidence maybe from the door or from the window, which is some of the normal places which he should process, and now mistakenly transfer it to a knife or an hammer that was found on the crime scene that has nothing to do with the crime. So at the end of everything, if you're able to link the owner of that probably maybe phone or knife, maybe we are able to know the person, then we think that it is the person that has committed that heinous crime. Now, when there is unintentional transfer of trace evidence to an object of relevance in the process of investigation process, then we say it is that contamination has taken place. But when it happens between 2 or 3 objects, then that is cross-contamination. For example, in a crime scene, maybe we found something like a knife, phone, then we have something like another object like a book, and we suspect that all these things were dropped there by the criminal or the suspect. If you pack the whole thing inside the same evidence bag, the trace evidence from one of them may transfer to others. So on getting to where we want to process all this object of relevance, it will mislead us into arriving at a wrong conclusion. So any contamination of evidence means that evidence is corrupt. That evidence is not reliable. That evidence cannot bring any solution to the case at hand. And there are 3 types of cross-contamination. 3 types of cross-contamination. We have material cross-contamination, we have digital cross-contamination, then we have cognitive cross-contamination. Let's go to the first one, the first type, which is material cross-contamination. Most forensic evidence, like DNA, hair, fibers, and paints, and blood are by its nature readily transferred from one item to the other. Please, are you following me?
Yes, we're following you.
We are following you, sir.
Okay. It is also possible.
Yes,
that
we can hear you clearly.
It is also possible that the evidence was transferred to the item through a third party during the investigation. This will be what we call cross-contamination, and such evidence is detrimental to any investigation. For instance, supposing fibers of hair from a victim are found on the clothing of a suspect, such trace evidence could be highly incriminating, right? But what if an officer or an investigator comes from the scene, from the crime scene, to the suspect's home and pack up all his clothes for forensic investigation and forensic examination? It is possible that the officer pick up trace evidence from the crime scene of the crime, from the crime scene, and acted as an intermediary, transferring it to the clothing of the suspect. Another good example of material cross-contamination is the case of a lady called Amanda Noss and her boyfriend that were convicted and sentenced to 25 and 26 years respectively. The case against nurse and her boyfriend solicitor was misconceived, and were sentenced because they found the DNA of solicitor, the boyfriend, being present on the kitchen knife, and on the bra clasp of the victim. That knife was found inside the room of the victim. The victim was murdered, and that victim was a friend and a colleague. But this is what really happened. After they have sentenced into different jail time, it was later discovered or found out by the Italian court that the DNA fragment from solicitor found on the bra clasp of the victim got there through solicitor having touched the handle of the victim's door while he was trying to force it open. They came and they suspected that something had happened to their colleague, to their friend, and they were trying to open the door by force. And while solicitor, the boyfriend of Amanda, was trying to open the door, his DNA was deposited on the door handle. And when they reported the case, because they didn't force they only tried, they didn't open it. But when the investigator was coming, he touched the handle of the door, and thereby he transferred that DNA into the knife that he found inside the room, the crime scene, and on the body of the victim. Thereby, after they have concluded their investigation, they arrived at a wrong conclusion that the DNA found on the body of the victim and the knife was the DNA of the perpetrator, whereas it was the investigator that mistakenly transferred it from the door onto the body of the victim. That's an example. Because of our time, let's move forward. Another one is another type is digital cross-contamination. Digital cross-contamination. It is easy to understand cross-contamination in a DNA laboratory or at the crime scene, but digital evidence has similar issues, which must be presented by the collection officer or the investigator. Cross-contamination in digital evidence may be subtractive or additive. Subtractive or additive. It can be either way. Now, it is subtractive when an information or file is unintentionally allowed by the investigator to be removed from the digital device under investigation when the forensic process is already activated. I will not try to go to some technical jargon because of some of us that are not into that field. But what the point is that when a digital device is seized from a suspect, and the investigator is trying to analyze it, the analyst is trying to analyze what is the information inside. There are some precautions that must be followed, as we heard it from the previous presenters. If this is not followed, it is possible for somebody to stay somewhere and still remove or add another thing into that digital device. So the investigator must be able to prove that he followed those procedures. So it is additive when an information or file is unintentionally allowed to be added to the digital device under investigation by the investigator when the forensic process has already started. For example, the cache of a device can be overwritten one way or the other if proper procedure is not followed. Or even somebody that is using a Celebrite and is not using Faraday bag, it is possible for somebody to write a code and send and make the code to activate some to start some things in the phone, which may remove or take something into the phone. That is, by the time the investigator might have finished his work, what he said he saw there is not what was actually there. So that one can be used to destroy case. Somebody, an innocent person can go to jail, or a criminal will be moving freely in the society. Let's move forward because of our time. The third one is cognitive cross-contamination. Cognitive cross-contamination. Cognitive is a mental process that involves understanding, perception, the way we see things, even learning, and so on and so forth. So the cognitive process stands at the center of forensic investigation techniques. Of most, not all of them, but most of them. So some technical processes in forensic investigation is comparing samples, analysis, and interpretation. And cognitive process is what you use for this. During forensic investigation, interpretations and judgment can be swayed without awareness of conscious control. Through priming from the relevant details of the examination. Priming is exposure to information that may make you to respond to another information in a certain way without awareness of your consciousness. You are not aware that thing is happening, but because you have been exposed to certain information, it will affect the way you react to subsequent information. For example, let's take this thing for example. If you prime by the idea of washing, and somebody writes S-P, if you are going to fill in the gap, you will probably include, you are probably complete it as soap. If you are priming with another word like eating, and they write S-P, you will probably going to fill it and make it to be completed as soup instead of soap because of priming. And that is how human cognitive process works. For example, in handwriting examination, we normally, there are some domain relevant information that you normally collect that is needed by a question document examiner to do his work. For example, you want to know the age of the suspect. You want to know his health condition during and before he made the document. Then you want to know something like whether he's on hard drug or alcoholic. So all these things, they are domain relevant information. But when you begin to, when the investigator or the examiner is being exposed to information that is not part of what he should use or what part of the what is relevant to his work, like telling him or letting him know that the fingerprint of the man or the suspect has been confirmed to be found on the crime scene, or that his DNA was found at the crime scene, or witness, or a testimony from a witness. All this can affect, can prime him to arrive at wrong conclusion. So exposure to domain relevant information may contaminate the examiner's performance that may eventually lead to wrong opinion. So as a lawyer or as a prosecutor or as a defendant, you need to know whether the person who have done the job, the examiner who have done that job, whether he actually followed the procedure that's supposed to follow, whether ethically he did everything. He must be able to prove it. Then, are there anything you can do to make sure that cross-contamination did not occur? Yes, there are many. So all these things, if we don't follow them, it will affect the outcome of our examination. And when the wrong conclusion is being made, it can make an innocent person to go to jail or even to be hanged. On physical evidence, the pre and post polymerase chain reaction, that is for DNA. That's for DNA. So there's a technology now that can help people to get DNA, even from a very small amount of DNA can be amplified so that they can easily get what the information they need from it. So we call it PCR, we call it post polymerase chain. That is just chain reaction. We call it just a PCR by the area where we do this should be constantly disinfected with diluted bleach. And also, in that laboratory, you must ensure that when you have pre, that is those things that you do before you started the work on it must be separated from where you have the post. The post will be what you do after the analysis. So these two must be separated and constantly must be disinfected, because it is possible for the work that you have done, the last work that you have done, to contaminate the recent one that you want to do if the place is not properly disinfected. Then personal protective equipment must be used. Any investigator, any crime scene investigator must prove that he used this PPE equipment. He must be able to prove it that he used PPE equipment. That is, those equipment are equipment that will protect the investigator himself from depositing his own trace evidence, or from taking trace evidence from another place to another object, or from one object to another object. Then there should be separation of victim and suspect exhibit, where you see some things from the suspect and those ones from the victim. They must be separated. If not, DNA can be transferred from one object or relevance to another one. Even can be transferred from one to the other evidence, while let the vessel as far as they bag, and so that this may prevent the reception of any information from outside. Then things like write block software must be installed. This will prevent intentional written, unintentional written, or erasure of the working copy. Then because of our time, let's go to the third one. For cognitive, forensic examiners should be shielded from primary information that can affect their cognitive process during the examination and analysis of forensic evidence. Also, continuous education and training for the criminal justice system and forensic investigation is required to ensure the proper handling of evidence from crime scene to storage and or laboratory to reduce the risk of contamination. In conclusion, the failure to prevent contamination can have significant consequences, including the inability to use evidence in court or even the wrongful conviction of an innocent person. Thank you for listening.
Thank you so much, Mr. Olomu Emmanuel, for that presentation. That was very educational. Thank you for that. I don't know if we have questions for Mr. Olomu.
I have observation.
Okay,
Okay,
sir.
sir.
Yeah, Mr. Olomu, I really enjoy your presentation. Very beautiful and wonderfully presented. I want to disagree a little that as an investigator, you must put all those precautions in place. That is, touching the handle of a door, thereby contaminating and transferring trace evidence. I think as before you get to that level of being an investigator, you must know that you must also clothe yourself with the right materials. Might be hand gloves, things like that also must be considered as an investigator, except whereby somebody else did that inadvertently. And the area of investigation is always condoned with forensic tape to restrict those who are not entitled to move, to work, or have anything to do with the crime, not to go close to the place. Then also, in the area of connectivity of a digital device, yes, you did mention write blocker software, but there's also hardware write blocker that prevents, inadvertently writing on the devices from which you want to extract evidence from. There are hardware also that is available if you want to extract evidence from a suspect hardware devices. Thank you very much. It has been a very beautiful presentation. Thank you.
Yes. Thank you, sir, for your observation. And I agree with you from the second point that you mentioned. I said I will not be talking, mention some technical jargons because of some of us. What the point is, those procedures must be followed. That is the baseline. But the first point that you mentioned, sir, the case that I cited was the investigator was not a novice, but it just as you be saying, every investigator needs to be trained and retrained. We need to be trained and retrained. And it's not
exactly
that the day that you became an investigator that you qualify that you be so experienced and know everything. And some people also carelessness can make them to not to do what they do. The case I cited, the police officer was wearing a pair of gloves, but the mistake that he made it was this: he used, before he got to that place, he used the PP. But while touching the door knob, the door handle, he is supposed to have changed it before touching any other thing. In fact, when you are touching different objects, you're supposed to be changing it, and that is why you on the crime scene, you're supposed to be wearing 2 gloves. Your superior may want to call you, so you remove the first one that you have used to touch anything. You use that one to pick your phone. Then after picking your phone, you remove it and put another one. So you still handle your phone without touching it physically. So those things is not the first day that you are qualified, that everything will just sink and you begin to practice it. After a period of time, you begin to see the reason why you should be doing all those things. That is why that's why a guardian like this is necessary. And many are not, even after their qualification, they will not bother to go further for training. So it's not about that everybody must know about this thing, but what we are saying is that that procedure must be followed. The baseline is that you should ensure that you follow it, because somebody, a prosecutor or a defendant that knows what he's doing as far as forensic technology is doing, we had that question, and if you are not able to prove it, then your evidence will just be thrown out of the court. Thank you, sir. Yes, thank you, sir.
You're welcome, Mr. Olomu. God bless you.
Thank you so much, Mr. Olomu. Do we have any other question for Mr. Olomu? Any other question? Okay.
Yes. Sorry, can you hear me?
Yes,
I can hear you.
Thank you. My name is Dr. Chinayamba. I have a question for Mr. Olomu. Thank you so much for your wonderful presentation. It is quite insightful. However, other than the experts, who needs to protect himself and all of this, and we are talking about cross-contamination here. In a situation where other people had responded to the crime scene, and we see this happen a lot in Nigeria because knowledge of forensic examination and all the precautions we need to have put in place is quite not very widespread. In a situation where people had responded and had touched things, we know you have always taught us that, and we have read that every contact leaves an evidence, where people had touched things before the responder or the expert comes in. How do we guard against this kind of cross-contamination? Because if they have touched the crime scene and then they go to other places, evidence will be transferred. And the case where police had not, or maybe had not responded, and then thereafter police goes and arrests people who are suspects, and any of these things have been transferred. How do we handle it? Thank you.
Okay, thank you, ma'am. What you are saying is true. In our society, people will not, there be a burglary case, or maybe somebody was murdered, and they will rush into that place and be doing all sorts of things, destroying or contaminating the crime scene. There was a case sometime last year, I think early last year. We were called for a burglary case in one church, and the person called me. I said, "Sir, I have some questions. Those are the questions you want to know. Some questions before you go into any forensic investigation, whether question document, whether crime scene, whether you need some questions that will help you." Now, after asking them what day, they told me it was like 2 days before that time. Then what is the kind of, what do they do in that place? Is it a normal house, or they say a church where they do program at least twice in a week? And I told them, what you are looking for may never be found, because what they want is that they want the fingerprint of the perpetrator, of the culprit. And I said, in that kind of gathering, so many people might have touched several things. And I thought they said they still want me to come. Perhaps I may get something. But on getting there, all the fingerprints that we got there were messed up. Some were not even readable. Some were so we couldn't get any meaningful, any readable fingerprint. Then, but one thing, we got the footprint of the culprit, why it was on a place where he used to climb to the room where he boggled and carted away their things. Now, in a case where such a thing has happened, you are from the inception, you let them know that if they still insist, if you must still go ahead and do it, in your report, it must be stated. It must be stated. For example, now, if you bring a question document to a question document examiner, and the photocopier, it's a photocopier, and you ask some questions. If that photocopy has been done several times, and you still need to go ahead, we tell them it's not advisable to use several copies, but there are some cases that you can do it and guess what you need. But if you have to let them know, then apart from letting them know, in your report it will be there that this and this and that this is your observation, but because of this and this and this may not do. So by the time anybody is reading that one, maybe you take it to court. The court place a kind of a caveat may not be certain, that the court may decide on its own to use or not to use it. But you can't prevent people from getting to that place before your knowledge, before you are aware of it. But you must know, you must ask questions, and if you know that they have already contaminated the place, then it must be in your report. Even that is if you must go and do it. But if there's